Hello, this is attorney Luceline Arat Kabading, and I'm going to talk about criminal law, its core doctrines, and fundamental principles under the Philippine law. So, the fundamental principles and key doctrines under the revised penal code forms the foundation of criminal law in the Philippines. So, I'm going to talk about the following topics: the principles of generality, territoriality, and prospectivity, the nature of felonies, actus reus and mens rea, impossible crimes, stages of execution and participation, conspiracy and accomplices, justifying and exempting circumstances, mitigating and aggravating circumstances, and a short overview of selected special penal laws. So let's start with the fundamental principles. First, the principle of generality. So criminal laws bind all persons within Philippine territory regardless of nationality. And the basis for this is Article 14 of the Civil Code and Article 2 of the Revised Penal Code. So for example, a foreigner who commits a crime in Manila is subject to Philippine penal law. However, there are exceptions to this, such as sovereigns and diplomats based on international law. And also under treaties, we have like the Visiting Forces Agreement. So a good case example is in the case of People versus Gozo, whereby the court ruled that jurisdiction attached the moment a crime is committed in the Philippines, regardless of nationality. Next is the principle of territoriality. This means that criminal law apply within the Philippine territory, and this includes Philippine archipelago, maritime zone, and the atmospheric space. Now, exceptions to these are under Article 2 of the Revised Penal Code, which says that even if committed abroad, the Revised Penal Code will still apply, such as offenses on Philippine ships or aircraft, when there is forgery of Philippine currency, when the acts are connected with Philippine obligations, and if the crimes are committed by public officers abroad in the exercise of their functions, and if these are crimes against national security and the law of nations. Example to these are treason and piracy. So a good example is if a Filipino sailor kills another Filipino aboard a Philippine vessel, even if it happens in international waters, this is still punishable under the revised penal code. Then we have the principle of prospectivity, which means that laws are generally applied prospectively and not retroactively. Now, the reason behind this is that no person shall be held criminally liable for an act that is not punishable at the time of the commission. So, but there is an exception to this. If the new law is favorable to the accused, so even if the case is pending or final, this is applied. This is the pro reo principle. For example, if a new law reduces the penalty for estafa, it applies retroactively to all pending cases. So a good case example is People versus Simon, whereby there was a reduction of penalty under RA 6425 as amended by RA 7659. This was applied retroactively because it favored the accused. Now let's talk about felonies under Article 3, specifically actus reus and mens rea. So when we say felony, this is an act or an omission which is punishable by law. And this can be committed by dolo, or there is malice, or culpa, there is negligence. So when we say actus reus, this is the external act, the physical element of the crime. And when we say mens rea, this is the criminal intent, which is the internal element. And so for dolo, which is committed by malice, there is an intent to commit the crime. While for culpa or negligence, this is imprudence or lack of foresight. So for example, in dolo, A intentionally shoots B. There is an intention, so this is homicide. While if it's culpa, a carelessly driver drives and hits B. So that is reckless imprudence resulting in homicide. So a good case would be People versus Valenzuela. In this case, it is distinguished between intentional and reckless crimes, and also that negligence does not in itself carry intent. Then we talk about impossible crimes. This is under Article 4, Paragraph 2. So when a person performs all acts of execution, but the crime cannot be accomplished because of following reasons, such as the object is improper, for instance, killing already a dead person, or the means employed are inadequate. So using a gun, but the gun turned out to be fake. These are what we call impossible crimes. And yet, even though the crime was not consummated, it is still punishable because the purpose is to repress criminal perversity, even though no injury occurred. So in the case of Intod versus Court of Appeals, the accused was firing at a house to kill someone who was not inside. And so that is an example of an impossible crime. Now let's talk about stages of execution and participation. Under Article 6 of Revised Penal Code, there are 3 stages of execution. These can be attempted, frustrated, and consummated. So let's differentiate. So when we say attempted, the overt act is committed, but the goal is not achieved. There is no completion of the crime. While in frustrated, all the overt acts are done, and yet the result is still not produced. So we call it frustrated. While in consummated, all elements are complete, meaning all acts were done and the result was produced. So for example, in an attempted execution, one aims, shoots, but missed. In a frustrated execution, one aims, shoots, but the victim survives. In a consummated, one aims, shoots, and the victim dies. In terms of participation under Articles 17 to 18, we have 3 kinds. One can be a principal, an accomplice, or an accessory. So a principal has direct participation or inducement, while an accomplice cooperates in the execution. An accessory assists only after the fact. So under the case of People versus Castillo, Supreme Court established that the mere presence of a person at the scene is not enough to indicate participation. One must show cooperation. Now, let's talk about conspiracy and accomplices. So when we say conspiracy, there are 2 or more persons agreeing to commit a felony and decided to commit it. So if proven, the act of one is the act of all. And this may be expressed whereby there is a direct agreement or implied, which is shown by the concerted acts. So in the case of People versus Lorio, the concerted acts before, during, and after the crime simply showed there is implied conspiracy. On the other hand, when we say accomplice, there is participation with knowledge, but with lesser degree of cooperation. So a key tip for the bar in terms of conspiracy and accomplices, always identify the degree of participation because this affects the penalty involved. Then we go to justifying and exempting circumstances. So when we say justifying under Article 11, this means there is no crime, thereby there is no liability. So there is no crime when it is in self-defense or in defense of relatives or strangers, or one is in a state of necessity. So in the case of People versus Nugas, for self-defense, there must be unlawful aggression, and there was a reasonable necessity, and of course, there should be lack of provocation. Now, under exempting circumstances, Article 12, the crime exists, but there is no liability due to the incapacity of the accused. So, for example, one is insane or imbecile, or one is a minor below 15 years old, and this is under RA 9344, or it was a result of an accident or an irresistible force. So in the case of People versus Formijones, insanity must exist at the time of commission so that it can qualify as an exempting circumstance. How about mitigating and aggravating circumstances? So in mitigating under Article 13, this reduces the penalty. So what are these circumstances? Voluntary surrender, a plea of guilt, or when the crime was committed in passion or obfuscation. Aggravating circumstances, on the other hand, increases the penalty. This happens when there is abuse of superior strength, or the crime was committed during nighttime, there is treachery or evident premeditation. So in the case of People versus Pantoja, there was treachery, which requires deliberate adoption of means to ensure that the execution is completed without risk. Now let's go to special penal laws. So we have RA 9165, which is the Comprehensive Dangerous Drug Act. So this covers possession, sale, and manufacture of illegal drugs. Now, for this case to prosper, it requires strict chain of custody, which is specified under Section 21. So in the case of People versus Hulgado, any break in the chain of custody is fatal to the good outcome of the case. Now, under RA 3019, which is the Anti-Graft and Corrupt Practices Act, this law penalizes public officers who cause undue injury or give unwarranted benefits. So in the case of Sanchez versus Sandigan Bayan, one requires proof of manifest partiality or evident bad faith for this Anti-Graft and Corrupt Practices Act to prosper. Under RA 7610, which is the special protection of children against abuse, exploitation, and discrimination, this law punishes acts of child abuse and sexual exploitation. Now, in the case of People versus Tulagun, there was a distinction here. Sexual acts against minors shall be prosecuted under the rape law, or RA 8353, if they constitute rape. However, it would be prosecuted under 7610 when committed through child exploitation or abuse of authority. So in conclusion, we have to remember that criminal law is not just about memorizing articles. Rather, it is about understanding what was the intent, how was the act committed, and what is the effect of the act. And so for the bar, always state the rule when defending or making the answer, apply the facts, and cite jurisprudence when possible. Because for one to earn points in the bar, one has to be clear with his answer, support it with the law, and make a logical reasoning. That's how you earn points in the bar. And so, I will end this lecture with the line, Actus non facit reum nisi mensit rea. This means the act does not make one guilty unless the mind is guilty. All right, folks, I hope you learned from this lecture. If you find this video useful, please don't forget to like, share, and subscribe. Daghang salamat.